because she's in the family. But also, Harriet grew up on a ranch near Fort Laramie, Wyoming. She is a water and natural resources attorney out of Cheyenne. She has worked diligently in her career to protect private property rights, and we're all about that. Harriet has handled numerous lawsuits against the federal government, including a successful challenge to the Fish and Wildlife Service's refusal to properly manage the Canadian wolf population that was introduced into Wyoming in 1995. She has more recently been focused upon pushing back against the EPA's efforts to take jurisdiction over Wyoming's water. Please join me in welcoming Harriet Hageman.
And thank you for having me. Can everybody hear me okay? Yep. I don't like to use microphones if I don't have to, and so if at any time during the course of my talk tonight you can't hear me, raise your hand and I'll make sure that I keep my voice up. I'm going to talk to you tonight about regulation without representation. And the point of this and the point of that title has to do with the fact that it's kind of related to our taxation without representation. And if you remember, we fought a war with England over 200 years ago because our forefathers said, we are not going to allow you to tax us and not allow us to have a say in our government. So our forefathers who fought that war were adamant that they should have the right to have a say in their government if they were going to have to fund that government. But what is now happening is we've got regulation without representation. And I'm going to explain to you today and tonight what that means. Before we get to that point, however, you go up. I want to talk to you a little bit about our financial situation, because this really is the foundation for everything that's going on in this country. As of July 23rd, 2014, the federal government debt was right at $17.599 trillion. That is a 208% increase since the year 2000. As of June 25th, it was $17.552 trillion. On the 13th of June, it was $17.3 trillion, and you can see the numbers up there. As of December of 2012, it was $16.3 trillion. It is $55,000 for every citizen. It is $151,000 for every taxpayer. And it increases by approximately $3 billion every single day. Now you may wonder, why are you giving us these numbers from July 23rd, 2014? And there's a very good reason for that. And that is that I typically, every time I give this speech, I update it. And I provide additional information, and I do additional research. And I look into the issues that I'm going to be talking about and finding out what's been changing since the last time I spoke. One of the resources I use is the United States debt clock. Today I went to the U.S. debt clock, and all of the fields are blank. What? There is no information on the United States debt clock today, which I find to be very, very, very strange, because it has all kinds of information. I encourage you to go to the U.S. debt clock, and hopefully at some point that information will be back up and running. So I went to some other resources, but I'll give you some additional information. The U.S. federal spending as of 7/23 was $3.5 trillion. That's the amount appropriated and spent. It is a 101% increase since the year 2000. In other words, in the last 14 years, our spending in this country has doubled. It has doubled in 14 years. It was $3.4 trillion as of November last fall. U.S. federal tax revenue this year is at a record-setting pace. This government has taken in more income tax this year than at any time in history. It is a 52% increase since the year 2000. The revenues were almost $1.4 trillion as of July, and we are continuing to run deficits. The total U.S. debt is $61 trillion, which again is a 134% increase since the year 2000. That is $757,000 for every single taxpayer in this country. Now I'll give you the information about today. I do have other resources to find out what that debt is. The total debt as of this morning was $17.915 trillion. Per person, that's $56,000. Per household, $145,000. The interest per year is over $500 billion. The interest per second is $16,000. The projections for next year is that we will have, by the end of fiscal year 2015, a little less than a year away, $21.897 trillion in debt for federal, state, and local governments, and an $18.713 trillion in debt for just the federal government. The spending spree, the 110th Congress from 07 to 09, they increased our debt by almost $2 trillion. The debt was $9.4 trillion as of December of 2010. You can see that from 09 to 11, they added $3.22 trillion, more than the first 100 Congresses combined. The 112th Congress added almost $4 trillion to our debt. And the outlays there was an outlays of $3.538 trillion for 2012. We've increased our debt since the year 2009 by $8 trillion. We are the largest debtor nation in the history of the world. President Obama's federal budget proposal for fiscal year 2013 is 3.8. His budget for 2014 is 3.9 trillion. And we are now entering the era of $4 trillion in annual federal spending. The CBO projects that deficits will exceed $1 trillion by fiscal year 2022. Now, why am I talking about this? What's the significance about this? Well, the significance of this is the way that our government is set up, the way that our Constitution is set up, is we have three branches. We have the executive branch, which is our president and our governors. We have our legislative branch, which is Congress and our state legislators. And then we have our judicial branch. I am primarily going to focus on the first two tonight, although after receiving a decision from a federal judge yesterday, that's the one I'd really like to talk about, but perhaps I ought to be a little bit careful. But we're going to talk mostly about the executive and the legislative branches. We're also going to talk about federal and state agencies. What happens once the legislation is passed? What a lot of people don't understand is we are a republic. We are not a democracy. We are a republic, and the significance of that is we have a representative form of government. When you vote for the president, or you vote for the governor, or you vote for your representatives, if you vote for a senator or someone for the legislature, they are to represent you. They are accountable to you. If you don't like what they are doing, you need to fire them. You need to vote for somebody else. A representative form of government is exactly what that word means. They are accountable to us as citizens, and they are accountable to us as their constituents. Now, what do we have? Statutes versus regulations. So our legislators, our congressmen and women, they pass legislation. That's the legislative branch. Examples of legislation are the Endangered Species Act, the National Environmental Policy Act, the Clean Air Act, the Clean Water Act. These are statutes. These are statutes that I deal with every day. These are just some of the federal environmental laws that I work with. So this book, it's not complete, but it has the Federal Land Policy and Management Act. It has the Atomic Energy Act of 1954, Clean Water Act, Endangered Species Act, as I've indicated. These are statutes. But what are regulations? Where do they come from? Regulations come from the executive branch. Regulations come from the agencies. Now what's important is that, what is important is that it is the people who are accountable to you that are supposed to be passing the legislation. It is our senators. It's our representatives. It's the people, it's your county commissioners. Those are the people who are accountable to you because you're the ones who decide whether they stay in office or whether they go. But what has happened over especially the last 30 years, 20 to 30 years, is it's the agencies that have become the real governing class. Now what's significant about that, what is important about that is they're not accountable to you at all.
Yep.
They have absolutely no accountable to you in any way whatsoever. And you don't even have to watch a news program for more than 15 minutes a day to understand what is going on with these regulatory agencies in terms of whether they are accountable to the citizens of the United States. In 2009, Congress passed 125 bills. There were over 3,500 regulations passed in 2009 alone. In 2010, Congress passed 217 bills. 3,573 regulations were adopted by federal agencies in that year. 2011, Congress passed 81 bills. There were 3,800 regulations adopted by federal agencies. In 2012, Congress passed 127 bills, and there were 3,700 regulations adopted by federal agencies in that year. In 2013, Congress passed 72 new laws, and there were over 3,600 new regulations. There were 51 new regulations for every law passed, and there was a new regulation adopted every 2.5 hours. This is just at the federal level. Keep in mind, you see that at the state level as well. We've got the DEQ, we've got the state engineer's office, we've got the highway department, we've got all kinds of agencies, and they're passing regulations on a daily, hourly basis. Problem is they are never answerable to you. So the unelected end up doing the majority of the lawmaking. Our elected officials, and this is also very important, our elected officials are also allowed to get away with not having to make difficult decisions. How many times have you heard an elected official say, those darn agencies, too many regulations, they're legislating by their regulations. We've got too many regulations. We've got those agencies. I don't know what I'm going to do with the EPA. I don't know what I'm going to do with the Fish and Wildlife Service. I don't know what I'm going to do with the Department of Energy. There's nothing we can do. That was a regulation adopted by an agency. What is happening is that our elected representatives are using agencies and the regulatory process as the scapegoat for not doing what they were sent to Cheyenne or Washington, D.C. to do. Agencies are incentivized to expand their jurisdiction, their oversight, their authority, their involvement. Because when they do that, what does that mean? It means more power. It means more money. It means less accountability. It means that they are a perpetual, they are self-perpetuating. You are never going to find an agency that might be put in place for a limited period or a specific purpose come out and say, we should now be disbanded. We should now go away. They evolve and they morph. They're kind of like the Ebola virus, and they can be created, and they can become something that has nothing to do with what they were originally designed to do. But the most significant thing from the standpoint of me, from my standpoint as an attorney, is they are absolutely unaccountable to every single person in this room. It does not matter whether they make good decisions or bad decisions, because they will not be held accountable for them. And you see that all the time at the federal level especially. Just to give you an example of the kind of regulatory burden we have in this country right now. This is just some data I got from NerdGas. This relates to information from 2011, so it's a little bit dated, and I need to get some updated information. NerdGas at that time had 209 total employees. There were 129 federal, state, county, and city agencies that one company that was governed by. 129 different agencies. Federal red tape, Army Corps of Engineers, the BLM, the Census Bureau. These are all of the federal agencies that Nerd Gas has to deal with. These are all the federal agencies that they have to comply with their rules and regulations. FAA, FDIC, federal FEMA, Federal Housing, Federal Reserve, Internal Revenue Service, Federal Unemployment, U.S. Department of Education, Department of Labor, Department of Interior, Treasurer. Here's your state red tape. These are your state agencies: Alaska Department of Natural Resources, Department of Transportation in nearly every western state, Illinois Department of Revenue, Nuclear Regulatory Commission, State of Wyoming, University of Wyoming, State of Wyoming Office of State Lands and Investments, various state income tax agencies, Board of Control, Department of Banking, Department of Child Support, Department of Enforcement Quality. You can see just one company that is responsible for creating over 200 jobs. This is the kind of federal and state bureaucratic nightmare that they deal with every single day. Wyoming New Hire Reporting Center, Wyoming OSHA, Wyoming Secretary of State, Wyoming State Engineer's Office. Then here's another problem, and this is where you see what I would refer to as redundant redundancy. Every state has a Department of Transportation, yet we have a Department of Transportation at the federal level. You've got an EPA at the federal level, you've got the Department of Environmental Quality at the state level. You've got a Department of Education, federal and state, Department of Labor, federal and state, Department of Agriculture, federal and state. So we are constantly, what we're seeing is that if there are conflicts, typically the state agencies will defer to the federal agencies. And my ultimate question, my primary question is, why do we have these federal agencies? All of these issues should be dealt with at the state level, whether it's Illinois or Florida or Texas or New Mexico or Wyoming. These issues should not be dealt with at the federal level. It's why we have 50 states. Every 50 states should be addressing these matters. The federal regulations are both costly and contradictory. The federal regulations, for example, we have the Clean Water Act, the Endangered Species Act, and the National Forest Management Act. We've got the state regulations for enforcement of the Clean Water Act, the game and fish regulations, and management of state forest lands. What else is happening is I've just indicated. What I have found, and I'm a water and natural resource attorney, and I deal a lot with state and federal agencies both. What I have found is that our state agencies are starting to identify themselves as essentially branches of the federal government. When I ask the DEQ about dealing with a Clean Water Act issue or a Clean Air Act issue, you know what they say? They don't say, Harriet, we're going to figure that out. Sometimes they do. I actually would rather work with the DEQ than the EPA any day of the week. But what they'll say is, well, we'll need to check with Denver. Last I checked, Denver wasn't in Wyoming. Why are we talking about checking in Denver? Because that's where Region 8 is for the EPA. I'm dealing with a dairy near Wheatland. I'm dealing with an overflow issue for a dairy near Wheatland. Why do I care what they say in Denver? Because Denver tells us what we can do in terms of fines. Why is Denver dictating what our fines should be? Doesn't this money go into the general fund? Shouldn't this be dealt with at the state level? Don't we have primacy over our water issues in the state of Wyoming? Well, yes, but we have to make sure that it's okay. So what you're seeing is that our federal agencies are subsuming our state agencies, and our state agencies are feeling more loyal to the federal government than sometimes they are their own constituency. And it's very easy to see where that happened. I don't know how many of you have probably heard about that so-called stimulus from 2009. Wyoming's share of that was several $100 million. I believe it was pretty close to $500 million. Friedenthal was the governor at the time, and I was at a meeting, and he sent his point person for the stimulus, the money that was coming into Wyoming, to the meeting to explain what was going on. And she came in and she had a flow chart, and she identified 56 different agencies that were going to be receiving money under the stimulus package. Well, my first reaction was, and I'm always the one raising the hand in the back of the room, I said, first of all, what does stimulus have to do with giving money to state agencies? I might be missing something here, but I'm not quite sure how giving money to state agencies is going to stimulate our economy. And then I said, and you do realize what the purpose of this is, don't you? I said, what? I said, are you going to reject the money? This is before the decision had been made. And I said, are you going to reject the money? And she ignored me.
Of course.
Okay, we'll try this again. Are you going to reject the money? And again, she ignored me. So yet a third time, whoa, are you going to reject the money? And she said, why would we reject the money? And I said, because you can tell by your flow chart what the purpose of it is. The blank look across the face, and I said, with that little tiny bit of money that is going to be sprinkled across those agencies, I assume you're going to have a whole set of rules and regulations and requirements of what each of those agencies must do in order to remain in compliance to get that money. Well, yeah, there are some things that we'll have to do to make sure that we're spending it correctly. In other words, for about $10 million per agency, which in Wyoming was a drop in the bucket at the time, you're going to allow the federal government to come in and take over 56 different agencies. And that was exactly what has happened. That was exactly what has happened. The federal cost to administer and police the regulatory enterprise is over $57 billion. That's just policing the regulatory enterprise. The number of current federal regulatory employees is almost 300,000, and it's increased by 17% under President Obama. We're not talking about your person who works for the Department of Transportation. We're not talking about somebody who might work for the BLM. We are talking about 300,000 people in this country. 1% of our population, right? 1% of our population, we're 300 million. So 1% of our population is employed by the federal government to enforce the regulatory, I guess you'd say, industrial complex in this country.
Good way to put it.
Agency interpretation of statutes. And I'll tell you what, this is where I absolutely go insane about what is happening in this country. What is happening is that when they talk about interpreting statutes, the purpose of regulations is to enforce or to carry out the statutes. Regulations don't exist just for the sake of regulations. The point of the regulations is to carry out some statutory provision that was adopted by Congress or our legislators. So a regulation is to carry out the Endangered Species Act. It is to carry out the Clean Water Act. That is the sole purpose of the regulations. And what you find is that they're not carrying out the statutes at all. And I'm going to give you an example of what I'm talking about. In 2006, I believe it was, Rapinos was a decision that came out in 2006. Rapinos is a decision issued by the United States Supreme Court. I do deal a lot with the EPA, I deal a lot with the Corps of Engineers, and I deal with enforcement of the Clean Water Act. And the federal government, the EPA and Corps of Engineers have been consistently trying to grab more and more and more and more and more power over our water, our waterways. And it has been pretty intense, especially for the last 5 or 6 years. So finally, the Supreme Court, in a 2006 decision, made a decision about whether what the EPA and Corps of Engineers were doing was appropriate under the Clean Water Act. And I'm going to read you some of the things that the United States Supreme Court said. The burden of federal regulation on those who would deposit fill material in locations denominated as navigable waters of the United States. In order for a waterway to be considered jurisdictional under the Clean Water Act, in other words, for the federal government to have jurisdiction over a waterway, it must be considered a navigable water of the United States. Navigable water of the United States. The burden of federal regulation on those who would deposit fill material in locations denominated as navigable waters of the United States is not trivial. In deciding whether to grant or deny a permit, the Army Corps of Engineers exercises the discretion of an enlightened despot, relying on such factors as economics, aesthetics, recreation, and in general the needs and welfare of the people. The average applicant for an individual permit spends 788 days and $271,596 in completing the process. And the average applicant for a nationwide permit, which by definition means that there is no impact to any navigable water of the United States, spends 313 days and $28,915, not counting costs of mitigation or design changes. Over $1.7 billion is spent each year by the private and public sectors obtaining wetlands permits. These costs cannot be avoided because the Clean Water Act imposes criminal liability, as well as steep civil fines of $37,500 per day on a broad range of ordinary industrial and commercial activities. And the court went on. The enforcement proceedings against Mr. Rapinos are a small part of the immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute. Read that to you again. The immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute during the past 5 presidential administrations. In the last 3 decades, the Corps and the EPA have interpreted their jurisdiction over the navigable waters of the United States to cover 270 to 300 million acres of swampy lands in the United States, including half of Alaska and an area the size of California in the lower 48 states. And that was just the beginning. The Corps has also asserted jurisdiction over virtually any parcel of land containing a channel or conduit, whether man-made or natural, broad or narrow, permanent or ephemeral, through which rainwater or drainage may occasionally or intermittently flow. On this view, the federally regulated navigable waters of the United States include storm drains, roadside ditches, ripples of sand in the desert that may contain water once a year, and lands that are covered by floodwaters once every 100 years. Because they include the land containing storm sewers and desert watches, the statutory navigable waters of the United States engulf entire cities and immense arid wastelands. In fact, the entire land area of the United States lies in some drainage basin, and an endless network of visible channels furrows the entire surface, containing water ephemerally wherever the rain falls. Any plot of land containing such a channel may potentially be regulated as a navigable water of the United States.
Unreal.
That's why I have the word interpretation in quotations. That's what the United States Supreme Court found about the expansion. In the last 2.5 years, I have tried 2 cases under the Clean Water Act against the federal government. Both of them were 2-week trials, absolutely brutal, because the federal government believes that it has unlimited resources and it spends money like it has unlimited resources.
Yep.
In both of those cases, I was representing one irrigation district related to a canal. It was allegedly a navigable water of the United States, and the other one was an irrigation ditch.
Jesus.
And in April of this year, I had a jury return a verdict in favor of my client for moving, straightening, and rehabilitating an irrigation ditch that my client had spent over $1 million defending himself.
Oh.
And in that case, what we were fighting about at trial, according to the feds, their numbers were wrong, we were fighting over 2.1 acres of land.
Jesus.
And they had forced my client to spend $1 million defending himself for rehabilitating an irrigation ditch. J.P. Morgan, loss of $2 billion, about 1.5 years ago, you may remember. And everybody was up in arms. Oh my God, J.P. Morgan has lost $2 billion. First of all, it was their own money. It wasn't client money. It hadn't been, like, who was the former New Jersey governor? I mean, he's out there stealing client money and nobody's all waked out about that. But J.P. Morgan lost $2 billion of their own money. And I remember listening to the news and listening to some of our congressmen and women say, oh my gosh, if only we'd had the Dodd-Frank regulations in place, this couldn't have happened. And And I thought, well, wait a minute, Mr. Senator. If it's not illegal under Dodd-Frank, the regulations can't make it so.
That's right.
You don't need regulations if it's either legal or it's illegal. The number of senators and representatives I heard lamenting the fact that we didn't have the regulations in place, and I thought, those are the people I need to go do this presentation for because they don't get this. Our own senators and representatives were saying if only we'd had those regulations in place. The regulations are not supposed to be interpreted that way. The healthcare law. The power of the Secretary of Health and Human Services. All right, Obamacare is already 2,700 pages. I'm going to refer to this as legislative malpractice, which is a term I should be using a lot more than I do, but it's clearly, if our congressmen and women are incapable of passing a law that is 2,700 pages long and have it self-effectuating without regulations needing to be passed, every one of them need to be fired. 2,700 pages. The lawyers have drafted over 20,000 pages of regulations for implementation. Over 20,000 pages of regulations. There are in excess of 180 boards, commissions, and bureaus.
Jesus.
There are 18 pages in the Federal Register to define a full-time employee, which has now been reduced to 30 hours per week. The IRS estimates that it will take 80 million hours a year for families and businesses to comply with the Obamacare taxes. The IRS estimates 80 million hours a year to comply with Obamacare. This is again coming back to this idea of interpretation of the statutes. This came across Greenwire earlier this year. Greenwire, Joe Goffman is the US EPA's law whisperer. His specialty is teaching an old law to do new tricks. Okay, that doesn't sound good to me. He is gearing up the 1970 Clean Air Act to be the vehicle for curbing power plants' greenhouse gas emissions.
Oh, geez.
But with no congressional action likely anytime soon to address climate change, Goffman's back at EPA. He works for the EPA now to help shape a new rule for working power plant fleets under a rarely used section of the Clean Water Act. Goffman has a sense of vocation to the Clean Air Act. He has been working on the law and its associated regulations for 30 years, often focusing on problems that were not envisioned in the original law and thus require, quote, new tools.
Uh-huh.
They can't get what they want legislatively. They can't get Democrats to vote for the cap and trade bill. So what do? They go hire them a consultant who will draft regulations to teach that old law new tricks. I've looked through the Constitution. I've looked through a lot of different things. I've never found anywhere where any of our founding fathers identified teaching an old law new tricks as being the authority of the executive branch.
Wow.
But that's where we are in this country right now. This is what the United States Supreme Court has said, however. An agency may not confer power upon itself. To permit an agency to expand its power in the face of congressional limitation on jurisdiction would be to grant to the agency power to override Congress. This we are both unwilling and unable to do. Agencies must always give effect to the unambiguously expressed intent of Congress. The power to execute the laws does not include the power to revise clear statutory terms that turn out not to work in practice. They can say this until the cows come home. Who out there is taking these cases and applying them against these agencies and trying to push back against these federal regulations? This is a decision that came out in 2014. Yet how often do we hear there's nothing we can do? Executive amnesty, there's nothing we can do. Cap and trade, there's nothing we can do. Again, it's called legislative malpractice. We've got to start pushing back against these agencies. Examples of our regulatory overreach. And really, we have gone crazy in this country. The Pythagorean theorem, it's a mathematical construct, 24 words. First Amendment to the United States Constitution, 45 words. Lord's Prayer, 66 words. Archimedes principle, again, a mathematical principle. 67, 10 Commandments, 179 words is all. Gettysburg Address, one of the greatest speeches of all time, 286 words. The Declaration of Independence, 1,300 words. The U.S. government regulations on cabbage crop insurance, 3,500 words. The U.S. Constitution with all of the amendments, 7,800 words. The U.S. governmental regulations on special rules for experimental populations of threatened and endangered wildlife and plants, over 36,000 words. When I said earlier about agencies have the incentive to expand their authority, to expand their base, to increase their power, to increase their authority, this is how they do it. The federal worker safety laws include some 4,000 rules dictating precisely what equipment shall be used and how facilities are built. Quote, stairways shall be lit by natural or artificial illumination. What might be my other alternative?
Unnatural illumination.
We pay people to write this dribble. Now what's significant about that is not only that we can laugh about it because it's so utterly ridiculous that there is somebody sitting in Washington, D.C. writing that kind of a statement, but the arrogance associated with it and the disdain that they have for the citizens of this country, that they would actually write something like that because they don't believe that our contractors understand that when they build this 12-story building, that stairwell must be lit. You've got people back in Washington, D.C. that actually believe that our contractors are too stupid to know that they're going to have lighting in that stairwell. That's what scares me. I'll pay the guy to write the words just as long as he doesn't believe that I'm an idiot. But this is the kind of disdain that is coming out of Washington, D.C., and it's scary because it gives them more and more of a reason to regulate us the way that they are.
Yep.
They think that they need to. They think that they need to adopt these things because we're not smart enough to know that you have to have it lit. They don't think that we are capable of taking care of ourselves. And that to me is a very frightening prospect because I think probably the most incompetent entity out there to take care of me would be the federal government.
Yeah.
But that's what these people want to do. Under a recent directive, the number of health care reimbursement categories will increase from 18,000 to 140,000 categories. It will include 21 separate categories for spacecraft accident and 12 for bee stings. There are over 100 million words of binding federal statutes and regulations, and the states and municipalities add even more. Really, we are crazy. This is a Health and Human Services regulation, administrative simplification, adoption of authoring organizations for operating rules, and adoption of operating rules for eligibility and claim status. I mean, seriously, I've read that like 100 times. I still don't know what it means. But fortunately, it's for simplification purposes.
Yes, but administrative simplification isn't that actually all?
Well, and there is a very serious side to this because of the costs. The real definition of a crisis. In 1992, the regulatory costs in this country were $400 billion. By 2008, those regulatory costs had increased to $1.75 trillion. That is more than income tax receipts. Now, what does that mean? What is a regulatory cost? How does that affect us? First of all, it's a hidden tax because you're all paying it. I'll give you an example. I work for companies that go out and get gravel. I work for companies that run gravel pits. In order to get a permit, a regular mine permit from the state DEQ for a land quality permit, it is upwards of $300,000 to file the application.
That's
When my
ridiculous.
client files that application, it is about this thick. And that is what is required at the state level to get a regular mine permit in the state of Wyoming to mine dirt, to mine rock. Now think about that. Gravel is absolutely one of the most basic of resources that we have to have. You don't have gravel, you don't have roads, you don't have buildings, you don't have highways, you don't have sidewalks, you don't have oil and gas wells. It is one of the most basic of resources that we have to have. My clients don't eat that $300,000. They can't. They pass it on to all of us. So this is a hidden tax, and it's a very significant hidden tax. And I personally believe, as much as I've been doing this, as much research as I do on regulations, I think what is going on in this country in terms of our economy and being able to get people back to work and creating jobs and all of those is more affected by what's going on in this regulatory environment than almost anything else that our government has done. I really do.
What did you?
And our government has made so many stupid mistakes that affect our economy. But this is the one, I think we've reached the tipping point. I think that we have truly reached the tipping point. These costs of that $1.75 trillion do not include Obamacare, Dodd-Frank, or the recent EPA regulations. Total regulatory compliance and economic impacts are over $1.86 trillion per year. The OMB used to publish this information, but after that number came out in 2008, they no longer publish the information. So I have to find other resources
Go
to see
figure.
how these numbers are increasing and what's happening. I actually think the 1.8 is low. I think it's closer to $2 trillion a year in terms of regulatory impacts in this country. In 2008, the regulatory costs were nearly twice as much as all individual income taxes collected. In 2009, Americans paid $989 billion in income taxes. In 2012, it was a little over 1.1. So far in 2014, we're well over 1.5 trillion in terms of income tax receipts, but the regulatory burden is $2 trillion. The important thing is that our income tax rates must be disclosed. So if I'm in the 25% or 36% or 40% income tax rate, by law, that has to be disclosed what rate I'm in. With regulations, there is no requirement as to the cost of a regulation unless it exceeds $100 million a year. And then the agency must say it exceeds $100 million a year. But they don't have to tell by how much. They don't have to give specific numbers. This may surprise you, but they have studied what because it's all self-reported, they have studied what the agencies disclose in that regard. They have found, and again this might surprise you, they have found that the agencies underestimate the impact of their regulations by right at 40%. Those are called economically significant regulations. The estimated cost of regulation exceeds half the level of the federal budget itself, and the regulatory costs of $1.863 trillion amount to 11.1% of the U.S. GDP, which was $16.797 trillion in 2013. In absolute terms, the U.S. government is the largest government on planet Earth, and regulations and deficits now exceed $1 trillion per year. The regulatory costs exceed all 2013 estimated corporate income tax revenues. They exceed individual income taxes, and combined with the $3.5 trillion of federal spending, Washington, D.C. of the economy now exceeds 31%. If it were a country, the U.S. regulations would be the 10th largest economy, ranked between India and Italy. Of the 4,062 regulations adopted in 2013, 224 were economically significant. 854 affect small businesses. 13 most expensive are estimated to cost the U.S. economy $515 billion. And Senator Rob Portman stated that those delayed rules, together with 130 unfinished mandates under the 2010 Dodd-Frank financial law, could significantly increase the regulatory drag on our economy in 2013. They amount to an average of almost $15,000 per household, and 23% per household, 23% of the average household income of $65,000. They exceed every item in the budget except for housing, and small businesses end up paying more. The regulatory costs, the future costs of the current agenda, the administration has averaged 81 major regulations each year from 2009 to 13. The 3,300 rules now in the pipeline, 191 are economically significant, And the House of Representatives has passed almost 40 bills to control regulatory expansion, but the Senate won't take it up. The six most active rulemaking agencies in 2003 are Treasury, Commerce, Interior, HHS, DOT, and the EPA, and they account for 49% of all regulations. The EPA regulation on carbon will destroy 1.4 million U.S. jobs and cost the economy up to $141 billion by 2014. 200,000 American manufacturers could lose their jobs. And from 2015 to 2026, the average annual impact of carbon regulation will be more than 500,000 jobs. And yet there will be no significant impact on reducing global greenhouse gas emission growth. Obama finally, in 2011, issued an executive order on regulations, stated that a government-wide review of the rules already on the books to remove outdated regulations that stifle job creation and make our economy less competitive. By November of that year, he had 580 rules already deemed significant, with an impact of in excess of $100 million. By December, he had 760 new rules. These are just some of the pages. I wanted to show you something. I don't know how many of you have seen the Federal Register, but this is a Federal Register from 1936. This is where all federal regulations are printed. This is from 1936. How many months of federal regulations? This is the New Deal. This is where the regulatory environment was born. It was under that president in 1936 during the New Deal that federal regulations first came into effect. How many months do you think this is in terms of federal regulations?
5.
4 years.
It's 6 months. This is 6 months of federal regulations from 1936. Now, this is the Federal Register today. This one's from 2013. How many months?
2 weeks.
5 days.
Oh, are you kidding?
This is 5 days. 3 columns. Tiny, tiny, tiny print.
Lots
This
of
is
words.
5 days. This right here is 1 day. 1 day of federal regulations.
That is so wrong.
That is so wrong. That is so wrong. This one they had to do 2 books because it couldn't all fit in one. These are 1 day of federal regulations that are coming out of the government. 2011, let's look. After this executive order comes out, by December we had 75,000 pages in the Federal Register, which would require 119 million hours of time in order to comply with them. So January 27, 374 days since the executive order, 0 economically significant regulations repealed within 1 year. Well, we already had 44 new rules in just that 1 month being significant. $7.7 billion, the cost of the regulatory burdens for that 27 days. On February 16, 2012, the EPA adopted the MAC, the Maximum Achievable Control Technology Rule and Regulation. According to the EPA, the cost of that rule exceeds the benefits between $1,600 and $19,000 to 1. I want you to get your arms around that. The EPA concluded in adopting this rule that the costs outweighed the benefits by as much as 19,000 to 1.
Jesus.
And they adopted it anyway. According to the EPA, it is the most expensive rule ever. That's an understatement. Electrical rates to skyrocket. You can see what happened as a result. 2014 is the highest, the most expensive electricity in the history of the United States. Right now, I was reading an article today about it. 2015 capacity that was held in May of 2012, 136 per megawatt hour, which was 8 times higher than the price in 2012. These are not estimates. These are actually what's been paid. According to PJM interconnection, capacity prices were higher than last year's because of retirement of existing coal-fired generation, resulting largely from environmental regulations, which go into effect in 2015. Here's just an example of what happens. This is what's happened in Europe. Opportunity cost for the UK subsidy system for renewable is estimated to be 10,000 jobs in just those 2 years. Planned offshore wind farm estimated to cost $9,000 per household. The cost of conventional energy is 80% of that. You can see what's happened in Spain. It's cost 110,000 jobs. That's where our government is headed. So then April 2012, we've got 465 days. We've got 257 new significant rules, but nothing repealed as of yet. We're up to 85.9 million hours of paperwork. Finally, June 22nd, 2012, we get one rule repealed. Spilled milk is no longer considered an oil spill.
How
I'm not
ridiculous.
kidding. That is truly what they did. It's the only rule that they have repealed. Finally, April of 2013, government slashes red tape with repeal of more than 1,000 regulations. Unnecessary regulation causes frustration and imposes costs on business, the community, and individuals, said Attorney General Mark Dreyfus. The regulations removed by this instrument form part of the more than 12,000 regulations the government will be repealing this year. Press release by the Attorney General for Australia. This is just a glance. 2013, 79,000 pages in the Federal Register. 2012, 78,000. 2010, 81,000 pages of regulations in the Federal Register. The cost of over-regulation, however, is not just monetary. And again, this is where I probably get the angriest in terms of what is happening. Our government is ruining our environment. Our government is destroying our environment. And I'm going to give you an example of that, and that is the 2001 roadless rule. Now, the 2001 roadless rule, it was pretty much the very last thing that Bill Clinton did on his way out of office. He actually signed it on January 12, 2001. This was to be his legacy. I was hired by the state of Wyoming to bring a lawsuit against that regulation, and we won at the district court level. The district court found that it violated NEPA and the Wilderness Act. But in the course of handling that lawsuit, I was able to get all of the administrative record that formed the basis for that decision. One of the things that I found in that administrative record, which was hundreds of thousands of pages. It was the largest administrative record ever produced in the history of the United States. I believe there was 56 CDs of information. The index to the administrative record was almost 500 pages long, landscaped, single-spaced. And it took me a long time to figure out how they were putting documents in there, because they don't give you the documents and you go through them. You've got to figure out a way to try to ferret out what are the documents that are going to help you. Well, I found 2 GAO reports. One was published in 1999 and one came out in 2001. And I'm going to read to you what they found was going to happen if the roadless rule was adopted. The proposed roadless rule takes an approach to decision-making on road construction in roadless areas that is different from the approaches of other recent Forest Service proposed rules, strategies, and plans. The proposed rule, which the agency asserts would supersede relevant portions of existing plans and transportation management regulations, would apply a national prohibition on road construction in roadless areas, even if local conditions suggest that a road would help the agency to restore and maintain desired ecological conditions. The National Forest could generally not construct a road to thin stands of trees and mechanically remove underbrush and dead vegetation to reduce the risk of uncontrollable and potentially catastrophic fire, or to improve the forest resistance to insects and disease that otherwise could kill trees and add to the fuel load. Officials in several national forests included in our review voiced concerns about the long-term impacts of the roadless rule. Officials on the Route National Forest, which is directly south of the Wyoming state line, the Route and the Medicine Bow are managed together. Officials on the Route National Forest anticipate an outbreak of pine beetles resulting from a catastrophic windstorm in 1997 that felled 13,000 acres of trees in or adjacent to roadless areas on the forest. They believe that the preferred alternative would not allow them to construct the roads necessary to remove trees in roadless areas that in the future may become infected by beetles currently living within this deadfall. Therefore, they would be unable to protect highly valued resources such as scenic areas and adjacent campgrounds and ski slopes. The federal government's response to that was, these are unavoidable adverse effects.
Yeah.
And now we know what happened, don't we?
Yep,
The pine beetle outbreak
yep.
was caused by the United States Forest Service.
Yeah.
And the fact that that has been covered up and hidden for the last 15 years is an absolute travesty. We have lost our national forests because of the roadless rule. There are 192 million acres of National Forest Service lands in the United States. They were set aside in 1896 under the Organic Act for two purposes: a continuous supply of timber and a continuous supply of water. They are managed by the Department of Agriculture, not the Department of Interior. They were intended to be a crop for the United States. They were intended to be used and managed, and properly managed. The roadless rule, when it was adopted, denied access, management, and use to 58.5 million acres of National Forest Service lands. Over 25% of our national forest lands have been placed off limits for any kind of use and management as a result of the roadless rule. Now again, I'm a water attorney. Guess what happens to our watersheds when we have catastrophic forest fires
That's right.
in those forests that have been denuded by the pine beetle outbreak? That can be laid at the feet of our National Forest Service. Interestingly enough, the vast majority of the people out in the field were adamantly, Forest Service employees were adamantly opposed to the roadless rule. They fought it as hard as we did. I have a stack of comments that are this thick that were submitted by Forest Service employees saying, please don't do this. You are going to destroy our national forests if you adopt the roadless rule. They were ignored, just like the state of Wyoming and the state of Idaho and the state of Montana, and everybody else was ignored. Everybody was ignored. They went forward, they adopted the roadless rule, and they've destroyed our national forests in the process. I remember arguing before Judge Brimmer and presenting some of this evidence as to the devastation caused by the roadless rule. The U.S. Attorney out of Washington, D.C. got up, and her statement was, we recognize that the roadless rule is going to be ecologically devastating in certain areas. But we believe that that is a small price to pay for having a one-size-fits-all rule out of Washington, D.C. so that we can manage our resources.
And she still has a
That
license?
was her argument. Ecologically devastating. My state happens to be one of them that's been ecologically devastated.
Yeah,
Send her the bill.
no kidding.
I wish we could. I
Send
wish
her
we
back to
could.
school, evidently.
Here's another problem that you have, and that is selective enforcement. What you realize is that these rules and regulations are not necessarily intended to be applied to everybody equally. They're intended to be used to scare people. They are intended for selective enforcement. You have an administration in place right now who is willing to use whatever resources that they have at their disposal to punish their enemies. And rules and regulations are no different than that. EPA Clean Water Act actions, ignoring the exemptions to the 404 permits. Right before the 2011 or 2012 election, you may remember that the Department of Labor was considering a regulation that prohibited anyone who was under 16 years old from working on a farm or ranch.
Yep.
They withdrew it because of the controversy associated with it. We know that they can't go out to every farm and ranch and determine whether there are 16-year-olds or 15-year-olds or 10-year-olds. I grew up on a ranch. It's why it turned out like I did. Maybe that's why they want to ban it. I don't know. But they're not going to go out to every farm and ranch. But all they have to do is go to a couple of them, right?
Yep.
All they have to do is say, Harriet Hageman is a loudmouth. Harriet Hageman has brothers who are ranchers, and they have little kids. How about if we raid their ranch on a branding day? That is probably one of the more insidious aspects. When you've got regulations of this magnitude, and this breadth, and this depth, and not being able to even understand them. You've got regulations of 20,000 pages under Obamacare, and I'll guarantee you that they're contradictory, that they're unenforceable, that it's not even possible to comply with them. But But then you have agencies who can interpret not only the statutes, but their own regulations. And they can do so in a way that is absolutely contrary to the very foundation and basis for our republic, for our constitutional form of government, for our liberties, for our freedom, everything. It is a very insidious situation that's been created. I'm going to wrap up here, and I'll take some questions, but what I believe is that the real crisis here remains largely unrecognized, and that is this regulatory burden at the local, state, and federal level. They're creating fuel poverty. These regulations are creating fuel poverty. We talk about low-income people. We talk about ways that we want to make sure that everybody has the American dream. The regulations coming out of Washington, D.C. are destroying that dream for many, many, many people. Our ability to protect our environment is dependent upon our economic prosperity. All you have to do is go to a country that is economically devastated, and they will be environmentally devastated. I will guarantee you there isn't a poor country out there that cares about the environment. Not one. They don't care about Clean Water Act. You look at what happened when Ceausescu was overthrown in Romania in 1989. You look at what happened when we went behind the Iron Curtain in 1989 and the early 1990s. What did you see? You saw environmental devastation.
Chernobyl.
You saw Chernobyl. You saw the things that they did in those countries, things that they continue to do in those countries. Go to Africa, for goodness sakes, look at what's going on with the Ebola virus. Look at what is going on around the world. And I will guarantee you that poor countries don't care about protecting the environment, and they don't care about greenhouse gases. They don't care about any of that. If we destroy our economy, we cannot educate our young, provide necessary services, or anything else. When the government directs its resources to doing things it should not be doing, it becomes incapable of doing those things that it should. And these are just two examples. I do not think that there is any better example for what is going on in the world right now than what is going on in our own government out of Washington, D.C. I've never seen the level and the nature and the type of absolute incompetence that is coming out of that cesspool like what we're seeing right now. They can't do anything right because they're trying to do everything. They want to tell you what your child can eat at lunch, and they want to tell you what playground equipment they can have during the recess, and they want to dictate what kind of shoes you can wear, and they want to dictate what the bottoms of the chair should look like, and they want to dictate what kind of lighting we have in our stairwells. And as a result, we're looking at potentially a pandemic that they're never going to get under control. A government that is closest to the governed is more responsive and accountable to the people that it is established to serve. Our representatives are answerable to us when they come to this room and stand here and listen to us. I don't have the ability to call Barack Obama in Washington, D.C. I'd like to, but I don't have the ability to do it, and he doesn't care what I think. But my county commissioners hopefully do.
Yep.
My town council hopefully does. My school board should. Regulation without representation simply cannot work. But there are some solutions. There really are some solutions to this. There must be an immediate moratorium placed on new regulation. There must be a comprehensive analysis of those that are already on the books. And the regulations must clearly state the statutory language controls, not the regulation, the statutory language. Regulations and the regulatory process must be simplified. And Congress and state legislators have got to stop committing legislative malpractice. How many times do you hear our representatives say, well, we'll pass this and then the agencies will adopt the regulations and then we'll go from there? That should not be their first response. They should not be considering or thinking about what regulations are going to come after their legislation. I've been practicing law for a long time. I have statutes that have absolutely no regulations whatsoever. They're fully enforceable. What is stated in that law is enforceable without a regulation. But I'm not sure even our own congressional representatives understand that. I think that they really believe that this entire complex is necessary to carry out what they're passing legislatively, and that is not true. We've got to reverse the top-down approach that we have been moving towards since the New Deal, and the President and Congress must be willing to return power to the states. I know it's a long shot, but we've got to be fighting for that.
Yep.
Concentrating power in Washington, D.C. does not and cannot work. We need to ensure that congressional and legislative oversight for proposed regulations. In other words, our representatives have got to review those regulations before they can become effective, and they need to sign off on them. And if those regulations don't say what the statute was intended, or they are broader, or they are changing something, they need to be held accountable. Our representatives need to be held accountable for what's going on in these agencies. We need to require congressional and legislative approval before any regulation costing in excess of X amount of money goes into effect. I find it absurd that a regulation does not even have to, they don't even have to disclose the impact of a regulation unless it has an impact of $100 million. Who came up with that number? That's absurd.
Somebody
But
likes
here's
to write
something
them.
else. If it's a $100 million impact, it can't go into effect until Congress votes on it.
Both houses.
Both houses. You want to see what would happen to this book? These books right here, they wouldn't exist. If Congress had to actually stand up and vote on 20,000 pages of regulations for Obamacare, never would have happened.
Yep.
If they have to vote on the MACT for greenhouse gases, never would happen. We have got to start demanding that people introduce bills at the state level and the congressional level that no regulation with an impact over 50 million, 100 million, 150 million, that if they cannot go into effect until our representatives vote on them. Never pay a regulator by the hour. Really bad idea to pay a regulator by the hour, because you will be regulated out of existence at your own dime. That's something they do in Laramie County. They bring in the regulators and they require the regulator to pay them. And those regulators come from Fort Collins and Denver, and oddly enough, they have to make a lot of trips to Wyoming to do their regulatory activities. Don't ever allow your government to pay a regulator by the hour. We have to have mandatory sunsets. Small entities need to be regulated differently. We've got to have individual accountability replace bureaucratic micromanagement. We've got to get back to the fact that we are an incredibly successful, competent group of people. What we have done in this country is mind-boggling. And we didn't do it because the government let us, or told us, or regulated us, or explained how it was done. We did it because we did it. We've got to get back to trusting our fellow man and understanding that they're going to be a lot better in the long run than the people in Washington, D.C. EPA, we need to abolish the administrative courts. We need to prohibit the EPA from seizing or destroying private property. I'm going to tell you, there are two bullies in the federal regulatory group, and that is the Fish and Wildlife Service and the EPA.
Yep.
Those are two agencies I work with. When I say bullies, I mean bullies. If you violate the Clean Water Act, you are subject to fines of $37,500 a day. There is no reason that Congress should have allowed that kind of authority with the federal agency. Because any agency that has that kind of power will abuse it.
Oh, yeah.
You can't fight against the EPA, because the letter that you get says that if you do not do what we tell you to do, we will fine you $37,500 a day. The guy I tried the case for earlier this year, 2.1 acres. As of February 2013, his fines were $67 million.
Look at Andy Johnson.
$67 million. That's what his fines were as of the spring, February of 2013.
That's unreal.
So, they didn't get any fines, but that was what he was subjected to for affecting 2.1 acres on his own private property in terms of remediating or addressing an irrigation ditch. They need to be barred from regulating CO2, the penalties must be dramatically reduced, and the agency's extra-constitutional activities must be barred.
Yep.
We need to make Congress directly answerable to the voters for the costs that agencies impose on the public. We just have to. You're not going to win it at the presidential side. That's all about power. We have got to make our representatives accountable for what's going on with our agencies. We need to pass the REINS Act. It has been sitting in Congress for quite some time. It requires Congress to pass and the President to sign a joint resolution of approval before a new major regulation issued by an agency may take effect. And we must develop and implement a legislative and congressional solution. State legislators must fix this at the state level, and Congress must fix it at the federal level, and you've got to participate in the process. All of these federal regulations are only adopted after there is a public process. You have got to participate in that public process. You've got to have your voices heard. You need to be pushing back on these things. And that's, I'll leave with Winston Churchill. If you have 10,000 regulations, you destroy all respect for the law.
Very well said.
And I think that's very apt. I would be happy to answer any questions.
Pass around the donation bucket right before we got to the name.
Harriet, are you familiar with the Andy Johnson case?
Yeah, I've been working with Andy.
Good, good,
Yes.
good.
He is a different attorney out of Cheyenne, but I visit with Andy on a pretty regular basis. We were in Riverton together when I don't remember what month that was, but he and I both spoke at a conference at maybe June of this year.
Yeah, I was talking to Glenn Woods, and he was on the radio with Andy at the time, and then I went on, and I told Andy, I said, keep it, you gotta fight.
You got to fight.
You gotta fight. I mean, they had us at $680,000 that we would have owed in fines had I lost our court case.
Yeah, we cannot empower these agencies or our government to impose those kinds of fines. I think they're unconstitutional. I just
Exactly.
think they're flat unconstitutional. Does anybody have any questions or comments? Yes, sir.
So Harry, this guy that's got a $67 million bill, basically, is that a situation where they can attach the land and foreclose the paperwork?
Absolutely.
Absolutely.
Are they gonna do that?
No, I won.
Oh, you won?
I
Okay.
won. Yeah, we won the liability phase of it.
But
But
what-
if he had lost, then yes, but we won the liability phase of it, and so we never went to the remedy phase.
So what
because-
process would they take the land by? How would they do it?
Well, you get a court judgment against you. So what happens in these cases is that you have two phases. And the liability phase, you can get a jury. And a lot of people don't know that. But if you're ever dealing with the EPA, the Clean Water Act, any of those, always ask for a jury. And so we had a jury, and we had a 2-week trial, and the jury found in our favor and found that David Hamilton, my client, had not violated the Clean Water Act by straightening his irrigation ditch. But what would have happened is if he had lost, then the federal government will present evidence, and we will present evidence about what a reasonable penalty would be. And then the judge gets to decide. It's not for the jury. The judge gets to decide. And it might be $250,000, it might be $1 million. It depends in part on whether you're wealthy or not. So it can be very, very, very burdensome. And it is really hard to win Clean Water Act cases. Really hard to win Clean Water Act cases. So there have been a lot of penalties imposed. If you don't pay them, if you were to go bankrupt, you can go bankrupt, or they can foreclose on you. And one of the things that they present during the course of the hearing is your income tax returns. And they brought in our case, he didn't get to testify again because we didn't go to remedy. They brought in an appraiser. And he would have appraised the property as to what it was worth so that the judge could do an appropriate onerous and burdensome penalty to make him hurt.
So this navigable water situation is actually an erosion of our private property
It's the point of it.
for the rights.
It is the point of it. I will tell you, we all know how important water is. We know how important it is in the western United States. We know how important it is in terms of there is what I would refer to, and we now have a Supreme Court justice who kind of adheres to this idea that most of your older water rights in Wyoming and in the West are held by ag because they're who settled, and we have a first in time, first in right, prior appropriation system. There are people who want to change that, and they believe that those early priority water rights should not be assigned by priority to ag, but should be assigned based upon the highest and best use, with a federal agency deciding what that highest and best use is.
Okay.
So what you have is that the point of what EPA is doing under the Clean Water Act and the new proposed rules and regulations is purely a property grab. It has nothing to do with the Clean Water Act. Our water is cleaner now than it has been in hundreds of years. I mean, it is, our environment in this country is very, very, very clean. There are situational situations, I'm not suggesting otherwise. The North Platte River, for example, you don't have high pollutants in there. This is a land grab. This is a water grab. It's to make your property worthless or to take your water without it. The Metropolitan Water District down in, we were talking about that earlier today, in Los Angeles, they take a tour of Wyoming every year to see what's going on in the Green River Basin. That's the headwaters for the Colorado River. They know more about what is going on in water rights in Wyoming in the Green River Basin than most Wyomingites do. It's money. In Colorado, they pay about $35,000 an acre foot right now for municipal water supplies. Yes, sir.
How does the state of Wyoming, since they supposedly own all the water, how do they react to what the EPA is doing in a land grab situation? I mean, are they cooperative? Are they pushing back? Or what I mean, is that?
No, we don't do anything. I went to them and tried to get them to help me on the Hamilton case. I went to the state engineer, who's a friend of mine. I went to the attorney general, and I met with them, and I explained what was going on. I said, this is very clearly an effort to use the Clean Water Act, water quality statutes, to take control over water quantity. Water quantity is supposed to be administered by the states. It's prior appropriation system, state engineer's office, all of that, board of control. I said it's very clear that they are using, this is my second case, that they are very clearly using water quality statutes to take control of water quantity, and I did not get anywhere. They would not help. I thought that if I brought the state engineer's office in and the attorney general's office in, and they pushed back against the federal government, I could potentially get them to go away, and I couldn't get them.
The state would want to maintain control of our waters.
Yes, they should.
What's going on with that?
They should, and if I were the attorney general, I would have been in the middle of that like that, because I know what the feds are doing. I fought too many of these. It's very clear to me what they're doing.
What's going on with that is that we've had 2 governors in a row who are federal persecutors.
Yep.
Quit voting the R.
Well, and it really is a problem when you've got somebody who identifies, because that's who handles your Clean Water Act cases, is out of that office. And when they identify that way, it's a problem. And that was under Friedenthal when I went to him to try to get some help on that case, and I didn't get it. I wish I would have. I think it was important. You've asked a very good question, but it's a question that should not just be directed to me. It needs to be directed at the people who make those decisions, because those are wrong decisions to make. They need to fight. Here's what you need to do if you're the governor. At every single opportunity, you need to push back against the feds. You need to call them into the office, and when they say, I hear about this situation with 2.1 acres at Wyoming, get out of my state. And you make a big deal of it, and you make it very uncomfortable for them, because here's something else I've learned. They don't try cases. They don't want to try cases. They don't like to try cases. They really don't even like to fight. What they like to have is they like to have the authority to hurt somebody with fines of $37,500 a day. But when push comes to shove, they don't like fighting.
They're bullies.
If you had states that really pushed to get back against a lot of these agencies, we could succeed on a lot of these battles.
The Oklahoma AG's office has something that we should try here.
What's that?
They have a department that deals solely with federal law. They have 5 attorneys there. They read the regulations and they push back.
We did. Dave
We used to.
Friedenthal did away with it. It was called the Office of Federal Land Policy. And it was staffed by some very good ones. It was in 2000, he was elected in 2002. No, he was elected in 2000 and, yeah, he would have been elected in 2002, right? And I believe that office was gone by 2003.
Matt Mead won't bring it back, I guarantee that.
But it was the Office of Federal, OFLP.
What's he got, 27
Office of Federal
lawsuits
Land
going right
Policy.
now?
It's a very good idea, and it was in place, and it was what was really good about it, there were several things that were good about it. I really liked the model. What was really good about it was that every time there was a proposed rulemaking that came out in this This person did nothing but monitor this nonstop. And any time that there was a proposed regulation or scoping or anything else that came out in this, it went to every single agency in the state of Wyoming that could potentially be impacted by it. Then they hounded those agencies so that those agencies would write comments as to why it shouldn't be adopted. So for example, the roadless rule, when it was adopted in the 1999 to 2001 period, I think Wyoming submitted like 27 different comments from 27 different agencies. So our Forest Service, our Department of Ag, our State Engineer's Office, our Department of Taxation, of Revenue, all of our departments commented on the roadless rule. And when I was arguing that in front of Judge Grimmer, that was very, very important to him because
Yep.
there were 1.2 million comments submitted on the roadless rule, but only about 67,000 that were substantive. And we had those that were from Wyoming, which I really focused on. And whenever the other side would say, oh my God, Judge, there were 1.2 million comments submitted and 99% of them were in support of the roadless rule, he said, I don't care what Wyoming say.
Yeah.
It was very important, and so that office would shepherd these. So whether it's the Department of Health and Human Services, or it's the Department of Education, or whatever it was, even though it was Office of Federal Land Policy, they did all agencies. So it would be HHS, it would be Department of Education, Department of Energy, all of those. Wyoming as a state participated very effectively in the regulatory process, but that office was closed in 2003.
That's sad.
I don't have a question so much as a comment.
Yes.
First, I'd like to say how much I appreciate the information you've given us tonight,
Thank you.
and also for pointing out the fact that we do have a republic still, and that our electeds are representative of us. And I agree with you. And like this gentleman said, the governor is a very, very important part
Yes.
of being our representative, and that they are accountable to us. But even more importantly, I realized this when I spoke at a county commission meeting not so long ago. Judy, you were there. You're always there.
I live there.
That as I stood there talking to Mr. Ringeter, I realized that not only as my representative do you represent me, but more profoundly, you act as my agent. You are me. And so what you do is me acting. So when our governor signs a law, that's me doing that to you. That's you doing that to them. Acting as my agent, I have to have somebody who is me.
Well,
And so for that reason, for me, this person must not only be accountable to me, but even more important, they need to be accountable for God.
well, they
And
need.
if they are not accountable for God, how in the world do we think we're going to make them accountable?
Well, and you make a very good point. The way that I would describe it or add to what you stated is that when our governor goes to Washington, D.C., or Nevada, or China, or Alabama, when he stands up to speak, he's speaking for every person in the state of Wyoming.
And I would say instead of he's speaking for them, he is me speaking. And so therefore, this governor that I elect with my vote needs to be me. And if I'm pro-life, my governor better be pro-life.
Well, and there's.
If I get the feds out, my governor better get the feds out and not just give me a real nice line about optical moments.
Well, and what we have got to do is the way that the 50 states, the way the original states were set up, was they are designed to be individual, if you will. You have New Jersey, and New Jersey is not California, and New Mexico is not Montana, and all states have their own independent personalities, if you will, and their own independent freedoms. We were talking this evening, and I think it's something that's very important for people to recognize. Our Wyoming Constitution provides us with more protections and more liberties than the federal Constitution does.
Yep.
And the federal Constitution is a floor. the way that that's been interpreted is when you look at the Bill of Rights of the federal Constitution, those are the minimum of what our government at both the state and federal and county level must provide to us. But our state constitution provides even greater liberties and even greater freedoms. And that's the way it should be. California can pass whatever ridiculous laws that it wants to. But we're not going to pass those laws in Wyoming. Wyoming should be able to do what it wants to do. We have our own independent personality. We have our own constitution. Part of what I see with this huge effort at the regulations and the federalization and the taking over of our agencies is that they are literally attempting to make it impossible to escape the stupidity of what some of these states do.
Yep.
I don't want to be like California. I don't want to be like New York. I don't want to be like Connecticut. I don't want to be like Rhode Island. I want Wyoming to be different. We're independent. We are, we're self-sufficient. We are kind. We are generous. We have so many things that are so different than what you see in other places. What they're trying to do is to prevent people from using their feet, using their ability to leave California, to say your policies are really bad. Because they like what California is doing, and they want what is going on in California to be imposed in Wyoming, so that people have to stay in California, or if they move to Wyoming, it doesn't matter anyway.
Well, and that was one of the things, too, that I love about Wyoming. The independent spirit of the people, that nobody can tell us how to vote. Nobody can tell us how to vote. And when we vote for a representative for us, who is us, we have choices that aren't on the ballot. And I speak, and everybody probably knows here, I'm speaking about the write-in campaign for Taylor Haynes. I have signs for people to write in Taylor Haynes. You're going to have to put your own write-in on, but I've got signs. And don't be fooled. There are people all over the state who have already written in Taylor Haynes. Don't be fooled. Wouldn't that be amazing to stand the establishment on its head, that people say, we have spoken, you've got to listen, and if there's only one vote. When I ran that referendum, because of the Casper City Council messing up the power of our vote, what did you say, Linda? Trifling with the power of our vote. Not only our vote, but our children's and grandchildren's vote. They have trifled with our vote. And people, I would say, will you sign my petition? And they'd say, well, I'm not registered to vote. And I'd say, well, shoot. And they'd say, I'm just so sick and tired of politics. And I got to tell you, I am sick and tired of politics. I don't want to manipulate a vote. I don't want to strategize. I want to vote for my representative, the one who is me. And that is the spirit and independence of our fellow citizens throughout the state of Wyoming.
I'm going to take this gentleman's question right here.
Thank you.
Sam, our knee-jerk reaction to all the regulatory coming out of Washington and elsewhere, historically, to me, has always been, well, I'm blaming the environmental movement. But it's become so large and encompassing, am I starting to blame the wrong movement?
No, because that's very much a part of it.
Yeah.
In fact, the roadless rule, one of the things that we brought is we brought what's called a Federal Advisory Committee Act claim when we challenged the roadless rule. And what that did is for the first time on a rulemaking, we were actually able to get discovery of the federal employees and some of the environmental groups. And what they've done is they had completely conspired to write the roadless rule before it ever went out for scoping. So I have emails and documents from August of 1999. The notice of intent was not issued until October of 1999. And the emails and the meetings were being held in the year previous to that, the purpose of which was to write the rule, and then they went out for scoping after the fact. It's one of the reasons we were able to show that it violated the National Environmental Policy Act, because they put the cart before the horse. So we did what was called a Federal Advisory Committee Act claim, and I got discovery. I went back to D.C. and I took 2 weeks of depositions of a bunch of federal employees. I was scheduled to take a bunch of depositions of the environmental groups, and Dave Friedenthal was elected in January of 2003. My depositions were scheduled for February of 2003, and he shut them all down. And would not allow
Go figure.
me to take those depositions.
I think that gentleman over there had a question.
Yes.
Regarding your case up in Warden, what powers do you have as a citizen attorney representing somebody if the governor doesn't tell the feds that they have no jurisdiction? Can you, as an attorney, work nullification under the 10th Amendment without the support of the state?
You know, I really did want the state involved in this, and they weren't gonna go there. You know, they might now, because I think it's become even more obvious as to what this grab is all about. You might see somewhat of a change of heart, I don't know. What you do is you make sure you get a jury. You gotta have a jury.
Gotta have a jury.
And because keep in mind, that federal judge is a federal employee. All right?
Mhm.
That's just the reality. And you have got to have a jury. And so if you have a jury, the U.S. attorneys are not very good at trying cases. They're good at bullying people, but they're not good trial attorneys. They make some really fundamental mistakes. They're not used to being in front of a jury. They don't typically have to go in front of a jury. And they don't know how to act in front of them. And they make some really fundamental mistakes with this jury. That's why it's so important to do it. So you've got to make sure, and you don't let up. I mean, you really fight. And David Hamilton fortunately had the resources and the personality and the fortitude to keep fighting this fight, because it took 6 years. That's the other thing. The federal government can seek $37,500 a day from you in fines, but they get to decide when to bring the suit. So my client did the work in 2005. They received the first report of it in the spring of 2006, second report in the fall of 2006. They finally made it out on the ground in August of 2007. They never issued a notice of violation until May of 2009, and they filed a lawsuit in October of 2010. And then all of those 5 years, plus the 3 years, and then we didn't try the case until 2014. I was hired in 2008. It took me 6 years to try this case.
Jesus.
And the entire time, that 37.5 is going every single day.
Wow.
Yes, ma'am.
What would it take to get a recall bill to recall representatives that we don't think are doing a good job prior to the election year?
I don't know. I've not looked into that. I'm sure it's statutory. And it's going to describe what you would need in terms of signatures and that sort of thing, what you have to do. I don't know what the numbers
Because
are.
Wyoming doesn't have that. You know, Colorado does. Wyoming doesn't have it. If in 2 years we have decided that need needed to be out, we had no recourse.
And I don't know the answer to that. I've never dealt with it, and that's not really my area of expertise. So I don't know how to answer that. Yes, sir.
This is another thing, I don't know if you'll be able to answer, but when I was following Taylor Haynes in his campaign, he was talking about the story of Clyde Bundy, the landowner, and he said that had been going on since the mid-90s or early 90s, but he had been raising fees for a long, long time, and it only came to a head recently. The reason it hadn't come to a head for that long, 20 years, was because he would call the county sheriff, Clark County Sheriff, every time that the feds would come on his property, and the Clark County Sheriff would kick him off. Is that, I mean, it just sounds too
Here's
simple
some
to be
things
true.
that happened
Is
about
that-
the Clive and Bundy thing that I just sent me right over the edge. The BLM has no legal authority to carry a gun on your property.
That's right.
Alright? They shouldn't be carrying guns. The BLM is nothing but a landowner. And if you and I have neighboring property and I'm trespassing on your property, you don't pull a gun on me. You call the sheriff. The fact that the BLM had guns and snipers and tasers and all of
Dogs.
that, every one of them should have been thrown in jail. The governor should have been involved in throwing him in jail. The sheriff should have been involved in throwing him in jail. That was nothing but a dispute between two landowners. I don't care if Clive and Bundy was trespassing or not. Self-help isn't allowed. It's illegal. I don't care if you're the federal government. What shocked me about what all went on out there was very few people understood how incredibly frightening that entire scene was. That you had a bunch of federal agencies packing heat in a trespass dispute.
Yeah.
That was crazy.
But they did have, the sheriff does have the authority.
Absolutely.
To do that. He can-
Absolutely.
So if I were in that position and I had some sort of federal agent for example, I mean.
Get off my property.
The position that I'm in, being a father, having, and my wife, we have children, and that's the one thing that I could see happening in is the CPS coming to take my children for some reason, right?
Call
You can
911.
call the sheriff.
Call the
They can-
sheriff.
And they can, so it's a situation like that,
Yeah.
that's the most
And
relevant.
even if, and then the trespass action is you file a lawsuit. You still have to file the lawsuit, and then if you, I mean, there is a process. We are a nation of laws. We are a nation of laws.
That's right.
The federal government has concluded that that the federal government and employees have concluded they don't have to comply with them anymore. And I know it's scary, and I know when you have children, it's easy for me to stand up here, but the fact is, somebody comes to my door, you show me the warrant, and if I feel threatened, or if I feel I need to get somebody else involved, I'm getting somebody else involved. What happened with that was an absolute travesty, and it was a terrible, terrible, and again, maybe these things happen for a reason. It woke up a lot of people. What are they doing with guns? Why do they have guns pointed at people?
And killing his cattle.
Yeah. And killing his cattle.
I
And killing
mean,
his cattle.
bulldozing his cattle right in the ground.
Yes, over here.
Yes, I have two questions. We have the code enforcers at our property. We live out in the county. And Linda, who was the code enforcer, said, don't fight it because you'll lose in court.
And who was Linda?
Well,
She was a code
they
enforcement.
threw her under the bus, but later. She doesn't work for him anymore. But she's a code enforcer who came out to our property.
Okay.
And she said, don't fight it because you'll lose in court. So that tells me that the judges, and my question is, when we vote for judges, is there any way we have some control over who we vote for? I don't have.
We don't vote for judges in Wyoming. We only vote to retain
Retain
or not
them.
to retain.
To retain.
Judges in Wyoming are appointed by the governor. And so, no, what ends up happening is that it's the judge that decides that. But here's what I'll say in response to that. I tell every opposing attorney that I deal with that you're going to lose. So it's not uncommon for somebody to say, even though I may not, I mean, the judge may ultimately rule against me. I tell them all the time, you're going to lose, I'm going to win. So that's just something that we say.
Some of my best friends are lawyers, and you know what they tell you? Never vote to retain a judge. Ever. They should all be changed out every time you can do it.
You have one more?
Yes. We had water that came out to our place, and we denied it. We didn't want to. We have a well. And my son said in Colorado, he said, Mom, I know a guy who they shut his well down. And I was wanting to ask you, how can they do that?
I don't know. I practice down there, but their laws are very different than ours in terms of water.
So they couldn't do that in Wyoming?
It's very hard for me to answer a question like that in the abstract. I'd have to understand what the circumstance was and the permitting and all of that. It's very difficult. I can't give a legal opinion on that without understanding all of the facts. Yes, ma'am.
This is in regard to the comment you made about the people coming up to Green River and looking at our watershed down there. In California, you know, they're going into a drought, and I read recently that they have studied tree rings of trees that are like in some lake north of Lake Tahoe, like they're prehistoric trees. And they found that the California area has undergone drought periods of as long as 260 years. So my question is, if this turns out to be a big one out there, what do you think is gonna happen?
Well, there's a couple of things. Part of the problem that California is dealing with in terms of their drought situation is they make really stupid decisions. Just a couple of weeks ago, they released over 27,000 acre feet of water to do some scouring on a channel. Stupid idea. Dumb. I mean, when you're in this kind of an extreme drought situation, you don't release water. Like I said, poor countries don't care about the environment. You make yourself poor, you're not going to be able to worry about the environment. A lot of the problems you have in California are man-made. I mean, they just are. They've got dams, they've got reservoirs, they have the ability to provide water to their citizens and to their ag. They've diverted it for environmental purposes. They're just dumb. So what are they going to do? It's what I'm talking about when I say that there are people out there who believe that there are higher and better uses for our water. We shouldn't be growing corn and alfalfa. We should be dealing with sending water to Mexico, sending water to Nevada, sending water to Arizona, sending water to Southern California. It is going to be a battle. It's why I fight the EPA on the Clean Water Act every chance I have, because it isn't about that particular fight. It's about control over the water. It's a battle that we have got to be fighting a lot harder.
So if you're just a regular person, is there anything you can do?
Tell your governor to fight water. Tell your representatives, water is absolutely critical. Do not allow the federal government to come in here and take it. Yes, sir.
Oh, I was just on your comment on the bullying and back to Clive and Bundy, like you said in the courtroom, the government isn't, qualified to argue, and they usually back down, or, you have an easy time with it. Same thing is that proved too, that civil disobedience backs them down too.
It does. Sunshine is the best disinfectant. It really is. And it's one of the reasons why I've always been a strong advocate of speaking out very, very strongly anytime you feel that somebody is doing something, whether they're in a position of power or not, because the government and government employees and bureaucrats tend to leave loudmouths alone a lot more than they do the people who sit down and take it.
Yep.
And I've taken on some battles with our previous governor, and what I realized is the only way that I could fight him was to make him think I was crazy.
Yeah.
Oh, yeah.
And
It works.
I mean, he knew that I would go public. If he didn't leave me alone, I'd go public. And a lot of people are scared of him. I'm not scared of him, but you have to say you're not going to do that. I'm not going to tolerate it. And what you find with bureaucrats, because they're not accountable for their actions, they want the path of least resistance.
Yep.
Had they known David Hamilton was going to take this case all the way to trial, they'd have left him alone.
Well, that was used to go out like this audience here. Well, we'll pick him, and we'll take those two to court. So all the rest of you're going to learn a lesson by this, because
Right.
we're going to destroy them too.
Right? Yes, sir.
Just want to make a quick comment. I have a dictionary at home, it's one of those that you put on a pedestal, it's about this thick, and all that, has every word in the English accent, in the English language, including all the definitions, the Constitution, all these things. The city building codes of Casper, Wyoming are thicker.
Regulations, I mean, it's at the federal level, it's at the state level, it's at the local level. I know.
That's where we got to start, right here in Casper.
Harriet, have you heard rumors of the state of Wyoming in response to droughts, thinking about assessing charges on private wells?
No.
I have heard that from state water engineer employees, that thought has been bandied about, that, for instance, in the North Platte watershed, they have been thinking about regulating the use of private wells and charging based on the amount of water that those wells produce.
Well, they can regulate them because the water belongs to the state.
And charge for it.
That part I'm not understanding. Yeah, that part I don't understand that, and I don't know what that is about. I'd have to look into that perhaps a bit more. We deal a lot with the state engineer's office, probably more than any other agency.
I'm sure there'd be a lot of pushback with the citizens who have wells, but I have heard that was a threat that...
Well, we are a conjunctive use state, which means we try to manage groundwater and surface water conjunctively. If they are hydrologically connected, we have to manage them conjunctively to the extent that we can, which becomes very, very complicated. So what is the challenge is that we are needing to deal with it more and more simply because we have more of a demand on the resources. So we do see more regulation now than I did 10 years ago.
Oh, yeah.
Yes, ma'am.
You mentioned as a remedy, one of the things that we should do is participate in the regulatory process.
Yes.
Now, I'm having trouble getting through to our current county commissioners, and what I feel almost has to be done is at the legal notice, when it appears in the paper as a legal notice, we need to start there before it ever becomes a law or an ordinance.
That's the process. When you go through this document, for example, There may be Department of Justice, notice of lodging of consent decree under the Comprehensive Environmental Response Compensation and Liability Act, CERCLA. They are notices, there will be notice of institution of formal enforcement proceedings. They provide notices in here too. It's not all regulations, although primarily, but it's notices of regulations, notices of meetings, notices of proposed rules, notices of intent, that type of thing are what are published in here. I actually have one of my businesses is we notify people of all federal and state regulations that impact water and natural resource issues in the state of Wyoming. We don't deal with education, we don't deal with healthcare, we don't deal with any of that. We have members that every day we notify them of any federal or state regulation that will affect water or natural resource issues. So we monitor the Department of Ag, and the Department of Interior, and the Fish and Wildlife Service, and DEQ, and we monitor all those agencies every day to see what they are doing that may affect any of our members in the state of Wyoming or the state of Colorado.
So where are you publishing this? Or
You have to be a member of one of our organization. I can give you a business card. I'm not the one who does it. I have staff who does that. But that's one of the things. But we don't do everything. You know, like we're not going to do the county commissioner stuff because it isn't what I focus on so much. But you have to get involved at the inception of whatever the rulemaking is, whether it's at the county level, city council, state, whatever it is. That's when you have to get involved with these things.
So can you speak to a training or a way to learn that?
Yes.
So you're ready and participating, because if we don't participate there.
Yes. In fact, I could come back up sometime and do that.
Would you?
Yes, or
That would
send
be
my
great.
staff to do it, because they're better at it than I am. But
That would be perfect.
yeah, I could work with Kathy at some point. We can come up and do some of that. But yeah, you need to submit comments. You need to participate.
Yes, thank you.
I'll only make one quick comment to that effect. If you don't submit comments during an official scoping period, you won't have standing.
You don't have
to appeal.
standing to later challenge it.
Really?
Yes. Yes,
Wow.
you won't have standing to later challenge it.
Thank you. Wow.
So you guys have been a great audience. Thank you.
Thank you.